Hello, hello, hello.
Good morning, Joe.
Hey, good morning, everybody. Letting everybody in.
Good morning, Joe.
How are you?
Good
Not too
morning.
all right.
Get all the humans
Hey,
going.
all.
No. Turn my audio. Okay. We'll give it another minute. Let folks join who are still jumping in. And I have a few things to update folks on. Um, shouldn't I don't know if we'll take the whole hour, but we'll make it available to you guys if you need it. But I might be able to give you some of your Sunday back because uh, there's some things happening, but I haven't got any big news as far as like the Court of Appeals or things like that. So trying to make sure I don't leave anybody in the waiting room. Is anybody else having a hard time hearing me? I have one person just let me know they're having a hard time hearing me. Can everybody hear me okay?
Yes, could you please be a little bit louder?
Yeah, sure. Let me go and look at my audio settings or maybe something going on there.
To be honest, it's always like it's you can make it better. Like it's muffled and really far. I always have a struggle. Thank you.
This is the first time hearing that. I have about I'm at my home on Sundays. Obviously, I have about any number of a dozen or so computers in this house for all. I mean, we have four people and I have iPads, laptops, all kinds of things. On our next meeting, I'll switch to one of the other computers. Right now, I'm relying on the microphone that is in the camera, and what I'm hearing you guys tell me is that that's not ideal. Um, there's another option that I can mess around with, but I don't want to test everybody's time today, which is to use my phone as my um, audio, but I'll just lean in and try to speak up. How about that? You guys let me know if it gets any better. I don't think you guys want to look too hard at my hairline. But so is that any better with me sitting a little closer and speaking up a bit?
It's good.
It's
Okay,
it's
yeah,
better.
I do.
It's
So
better.
just so you guys all know that this is being recorded. I make a habit of going back after, we record these. before I post them, because I put them on the YouTube channel so that you guys can see them. That's why I tell you, like, be careful, don't put too much personal information out here as it relates to the stuff we're talking about, because it's for your edification. This is for you guys to learn from them and then keep caught up and then have a reference for, hey, what did Joe say in the last time we had a meeting? And that's why we do that. Let me make sure I'm letting everybody in. All right, we've got about 18 people, well, including me in here, and some others might come in. I want to give everybody a quick update on some things that have happened in the last couple of weeks. I'm going to try to get apart from, holidays and things like that. Like we missed Mother's Day and Father's Day on purpose. One of the weekends was 4th of July, Memorial Day. We tend to skip those. But other than that, I'm going to try to stay on this bi-weekly cadence to update people on what's going on with the case. On a Whitcomb law side, or Whitcomb, what was previously Whitcomb Selinsky, I have, over the last week, I have meaningfully downsized the size of the firm, because I have, this case has gotten to a point where it's demanding, as you guys can imagine, a lot of my attention. You guys have had, you have met, most of you now have met my wife through this case, where it's kind of an all hands on deck situation, because of the fact that there are now over 300 of you, and you all have your individual questions and concerns, and that's actually sort of the nature of this case. It is not, I've said this, I try to say this essentially every meeting. If this were a class action, like we've talked about before, like Ford puts out a bad tire, and 100,000 people are affected by this bad tire, that is the stuff of a class action. And that means that the class representatives end up negotiating on behalf of all of the class members, and whatever the class agrees to, the class members are they're not obligated to say yes to that, but if they say no to it, they're forced to go out and start their own case, right? In this instance, we've got what's called a collective, so that's like a class action, but it's turned on its head. So you can't wait until the end of this case to figure out what you want to do. You have to join at the beginning, and your damages typically would go back 3 years from the date that you joined the case. As most of you have heard me talk about, I am arguing at the Court of Appeals for the Federal Circuit for the right to argue back pretty much an unlimited period of time, but at least going back 6 years from when the case was originally filed in 2021, which would take us back to 2025. That's because the original case was filed in 2021. As you guys have heard me talk about, Judge Summers has put up a number of obstacles. I don't want to guess as to what his motivation was. Could be the fact that he got reversed at the Court of Appeals, or it could be that he's just trying to save the government money. I'm not really certain, but we've got this case at the Court of Appeals, and we're trying to look back to at least 2015. And my fingers are crossed. There is another hurdle we can cross using what's called the accrual suspension rule, which was argued on a case that was at the Court of Federal Claims, which says the 6 years does not begin to run until the individuals learn about their ability to bring a suit, which for most of you was not until 2024, which means it's not going back 6 years from 2024. It means that it would be 6 years from 2024 going forward that you can file. So all that to say, or in many of your cases, 2025. So I'm trying to go back as far as humanly possible. I'm trying to be conscious of time because I want to leave room for questions, but let me update some of you on some other issues. Last time we met 2 weeks ago, we talked about the Gilbert law suit. So I would say I've had the good pleasure of being able to speak to Ryan and Kevin, his partner, over at the Gilbert lawsuit. Many of you probably who were on that suit got an email from Ryan saying we're both comfortable with everybody being in both cases. And I got confirmation from Ryan on that case. That case is specifically for the PSCs who were terminated at the end of May 2025 or thereabouts. I know a huge crop were separated by the end of May. And the idea behind that case is that termination was unlawful based on the fact that the appointment that President Trump's appointment over the VOA was illegal. We saw that play out in the news. And so that's the basis of that claim. Now, that's a Contract Disputes Act claim, something I spent some time sharing some of my knowledge with Ryan and Kevin on that front. I think they knew most of this, which is that requires a Contract Disputes Act claim be filed with a contracting officer. Once 60 days have gone past on that, that's called a deemed denial. And then you're able to file suit in the Court of Federal Claims, the same court we're in. But the damages in those cases are limited to contract damages, meaning that if you were supposed to be paid $40 an hour through the end of the contract period, which would be, most of you know you were on like a base period plus option years. The government will argue option years are what they sound like. They're options. We don't have to exercise them. So that'll be a limited pool of damages based on contract damages under the Contract Disputes Act. My case that I told you all that very much overlaps that but is not mutually exclusive. It's just a different theory to get to a pool of damages is the FLSA anti-retaliation statute that says you're not allowed to fire somebody if the purpose for an illegal purpose related to FLSA. So my argument is the government engaged in those firings rather in an attempt to end this FLSA action, right? They're trying to cut off damages or cauterize damages at the point of firing, saying, look, we won't owe anybody any more money after this. I amended the complaint to bring in a retaliation claim under the FLSA, and that's when I told you Judge Summers says that court doesn't have jurisdiction over. That issue is up at the Court of Appeals. I have a lot of confidence. I believe that the law is very much on our side on that, and that we'll win that, which means we'll have forward-looking damages, and you'll have liquidated damages, which means the amount of money they owe you times 2. So that's where, and again, Ryan and Kevin are super smart. I was very impressed with both of them. Kevin is the partner. He actually knows some of the Court of Appeals judges by name, which is super rare to meet people who know the judges on the court by name. And so I feel like they're a good team, and we're going to collaborate together so that we can share information about not about your personal information clearly, but about legal strategy going forward, so that we can kind of double team the federal government, at least as it relates to the PSCs who are working for the VOA and then got terminated at the end of. I'm going to mute you, Jennifer, okay? Because I can hear you over there. All right. So the folks who were terminated at the end of May 2025. I think you've all heard me raise this argument, but the argument that I'm raising relates to a doctrine referred to as temporal proximity, is that I was in court on May 7th, 2025, arguing on behalf of this FLSA claim. And I was doing that in front of about 8 government lawyers, some from VOA, some from USPS, some from NIH. VOA was certainly represented there. So, and of course, the United States government was represented by way of the DOJ attorney. So they can't say, well, we didn't know about the FLSA action. They clearly knew about it. And in our view, the world retaliated. And again, if it doesn't have to be like anger. It doesn't have to be spite that they did it. It can be for the purpose of trying to end the damages. That's a violation of the FLSA, Fair Labor Standards Act. So Kevin and Ryan and I are going to be working in concert. If you guys go to the Whitcomb Law PC website, you're going to see that it shrunk tremendously. When by the end of this month, it will be me, a paralegal. My wife will be on the website, probably is helping me. She's going to be working obviously out of home, but we're going to be kind of just entirely, if not 100% focused on this case, 80% focused on this case. I've got a small number of personal injury cases that they're not really personal injury cases. They're more like USERRA claims that I'm working through. And once those cases are done, I'm not taking any new cases in on that front. I am helping, veteran-owned businesses with their government contract issues, but that's pretty much muscle memory for me. It doesn't take a lot of work, and I'm not going to build a staff anymore. So you guys are going to have maybe a lot more of my attention than you originally bargained for. And I'll be, working with, I still have Forrester Haney as a backup if we need to start deposing people. Right now, they're just kind of playing a role in the shadows. The folks at Gilbert are inside the Beltway in DC, so they're useful to be close. And if we need to use offices for deposing government witnesses and things like that, I'm guessing we should be able to do that. I haven't had that conversation with them yet, but that'll be in the conversations going forward. So a lot of you have asked me, like, hey, is it a problem for me to join that case? The answer is no. It's a completely separate cause of action. But both of us have agreed that if the government offers a settlement for anybody, that we'll collaborate so that, because what I worry is that the government will come to you guys and say, hey, if you agree to settle this CDA claim for $5, then and blow off the $10 that you would have gotten for the FLSA action, then they'll ask you to sign some sort of global waiver. The position that the two law firms are going to take is, look, I'm in no position to negotiate for a client as it relates to the Gilbert case, and the Gilbert people are going to say the same thing about not being able to negotiate for the Whitcomb case. So I am right at 15 minutes. I've said a lot of words. Oh, one last thing. I'm going to give myself just a few more minutes to update you guys on the amended complaint. Some of you, a good number of you, saw an email come out from me. I was looking for some additional named plaintiffs to go for, specifically for VOA, to go into the case, people who had already opted in, people who had damages after 2021, who had shorted overtime. And I have like 8 now. So and I have the amended complaint and the memorandum of law and the motion to amend is filed. I'm doing some final edits. Those people who are going to be named plaintiffs, they know who they are. They've sent me emails saying, they're good to go. The only thing I have left to do is to send I'm going to send, and I'm picking on Jason all the time because he's on this, but I'm going to send Jason his portion of the complaint and say, hey, fact check this, make sure I've already got a statement from him, a sworn statement, but I always believe in like double, triple checking, making sure that everything we put in here is correct. And then I'm going to get that, my fingers crossed. I've got a lot going on this week. I've got to move a bunch of office furniture out of an office, things like that. My phone numbers, my email address, none of that stuff is going to change. I'm going to give up the office that I'm spending like $23,000 a month on that I'm not going to any longer need. I'll be working out of my home. Everything's going to be, I'm still going to be fully operational, fully visible for you guys. I'm cutting about $3 million of expenses because in my mind, I'm going to need the time, energy, and money to pour into this case. Because if I'm right about what I believe is true, there's about 300 folks in this case right now. I expect that, we'll end up ultimately, once we get all of the agencies who've offended in the ways, VOA is not the only offender. You guys know there's State Department, DOJ, and NIH, USPS. There's a bunch of agencies who have offended. Once we got everybody in this thing, I expect we're going to have, in excess of 1,000 people in this case. And that is going to be a very time consuming effort. And there's going to be, the firm's going to end up spending a lot of money as it relates to flying to DC, deposing witnesses, paying for transcripts. And I'll be doing all of the legal work myself with some help from Forrester and maybe some help from Gilbert on some of it. But at the end of the day, like I just needed to I couldn't do both things, which is run a 35-person law firm and give this case the attention that it needs. So I paired that, the first thing, back to what will essentially be 3 people is what I think we'll have. 3 to 4 people total when it's all finished. So again, I have said a lot of things, and a lot of it was probably news to you guys. Maybe I wouldn't know why you would know the other stuff. Now there's 23 of you, a lot of usual suspects, people I've seen before. So we'll do the thing we're used to doing, which is if you have any questions, just hit the little hand raise emoji, and then I will call on you and we'll get your questions answered. Got about 40 minutes left in the hour if people have questions. Ignatius,
Hi, Joe. Good morning from Seattle area. How are you? Can you hear me?
sorry.
Can you hear me?
Yeah, I can hear you great. I can
All
hear
right, good. So again, thank you for the work that you do. A colleague of mine who used to work with one of the language services, part of the, contractors who were, asked to go back to their home country because she came here solely for the VOA,
you. Right.
reached out to me last week, and some way, somehow, I forgot her within the members of my body when all this was going on. Is it possible for contractors who've been told to go out to wherever it is that they live to join the lawsuit?
100 so there is no geographic. I'm going to try to answer it this way, Ignatius. There's no geographical boundaries on this case. The only thing that I have to make sure of from a geographical perspective is that when they were doing the work for VOA, they were subject to the Fair Labor Standards Act. And that requirement has nothing to do with citizenship. It has only to do with where the work was being performed or the contract, like where the contract was being performed. Um, so what? So the answer to your question is she can certainly join the case. She's still eligible for the money, even if she is, living outside of the United States now, because my expectation is she was here in the States doing the work when that happened. And there's even some RFE folks, some Radio for Europe folks that I'm trying to look at their contracts to see if those contracts state, for example, that U.S. law controlled the relationship, then I can use that to get them into this case.
And so thank you for the answer. So she would be right in line to join
Yes.
now, even if she wanted to.
All she has to, and you guys all that link thank you for asking that question because it gives me another. So I every time I send out an email to you guys, the link for completing a form is in that. That is not for the to say, hey, fill out another form if you filled one out before. I've had folks, some of you guys are so sweet. Some of you fill out like 4 or 5 of those forms. One form is adequate. If you need to make fixes, you can certainly fill out another form. But that form link is in every email for that very, like if you know somebody that has not joined the case that you think might be eligible, all they need to do is fill out that form. I'm reviewing every one of those forms, and I'll know what, if they don't fit, like a small handful of folks have not fit into the case. Like they were always paid overtime, never missed any minimum wage, they never worked off the clock. They did, now they still would fit into the termination, in my view, would still fit into the retaliation part of the claim. So just send that form to folks if you think they might fit, and tell them to spend, I think it'll take them 20 minutes max, maybe probably 5 or 10 minutes max to fill that form out. And then they will go right into my portal and I can go to work on it. I've got about 3 or 4 from the last week that I've got to bring in.
Thank you, Joe.
Perfect. I think my next hand in the order is Marie. Good morning. How are you?
Hi, Joe. Good morning. I'm so happy to hear back about our appeal in the court. That's a very good news for us. So my question to you was, I don't know if I received a statement yet. I know you have reappeal mine back in January, but do I need another statement or what
Nope.
you have is already good?
You in particular, if you don't mind, so you have 2 cases going on right now. One, you're on appeal. Court of Appeals Federal Circuit for the Fair Labor Standards Act. That's the minimum wage and overtime theft claim, right?
Yes.
And you have a separate claim going on at the USPS, which is the Federal Torts Claims Act. Now, guys, you're going to feel like you won't feel like lawyers by the time this is over, but you might feel like you could play one on television.
Okay.
So the FTCA claim is the Federal Torts Claims Act claim, which is based on state law. You living in Texas, it's Texas law that says it's illegal to misclassify people. So that you have 2 cases going on in tandem right now.
Okay.
About 86 of you have at least two cases going on. Those are folks that were illegally classified. Those had some Federal Torts Claims Act issues. I'm looking for any state laws that these folks violated on top of the federal laws that they violated with the Federal Labor Standards Act. I've had a couple of people who were injured on the job and didn't have workers' comp. That's a state law violation.
Okay.
So I'm bringing those.
Okay. Sounds good.
Does that answer your question, Marie?
Yes, you have. Thank you, Joe.
Perfect. All right. I've got, all right, so Marie Mohammed,
Good morning. Joe,
morning.
and good afternoon for those on the East Coast. I'm coming back again to this issue of overtime. In my case, I would say we have likely in my case, three stages about this overtime. The first contract was an individual contract with the VOA, which is BBG. Initially, those times were making overtime and they were paid at some point. And then for some reason, one day they confronted some, budget and all those financial problems. That's where they handed the contract to Netcom. But I was never an employee for Netcom, but I was a subcontractor because
Sure.
I didn't accept the position to be an employee for Netcom. They said, okay, based on the record and what I did initially, they will accept me as a subcontractor
Right.
and keeping the same salary I had before joining Netcom. So we had this problem over time. Sometimes when they call you in the weekends, you didn't get paid, or sometimes they pay you, sometimes they
Sure.
don't. And the third leg of this is when I joined as a PSEs. Initially, they were paying us over time. And at some point, they decided to change overtime because they don't have enough funding. They said,
Right.
okay, it's going to be comp time.
Yep.
Rather than pay you one time and a half, you got comp time. So I don't know if that part is involved in this process of overtimes or not, because we didn't get any, money for it, but you can file for the comp time. That's at the stage as PSCs. So is there any discrepancy between these forms of overtimes?
So Mohammed, am I saying your name correctly? Is it okay to call you Mohammed?
Yes, Mom. Yeah.
So Mohammed, I want to thank you for your question. You don't know that, I don't think you know that you did this, but you asked about, you outlined about 4 different things that various folks did that were illegal. Okay, so this is going to be a little bit of a law school class again. So did everyone probably heard Mohammed say, I was a salaried, you heard him say the word salary and subcontractor in the same sentence, right? That animal does not exist in nature. There's no such thing as a subcontractor who is on a salary. You all know what a subcontractor is. A subcontractor or a contractor is a person you ask to come out to your house and build a deck, and they quote you a price, and you pay them that price, and they build that deck. That's what a contractor looks like. No contractor comes to work for you and you say, I'm going to pay you an hourly amount. That's not a contractor. That's called an employee. And the fact that you agreed to do that with Netcom is irrelevant to the question, because it is not the employee's responsibility to make sure the employer is following the Fair Labor Standards Act or the state's classification rulings, right? If you came, Mohammed, and offered to work for me as a paralegal for $1 an hour, and I thought to myself, what a great deal. I'm going to get $1 an hour work, and Mohammed's going to work 100 hours a week. It doesn't matter that you agreed to it. I am not allowed to break the law just because you agreed to do it. Does that make sense? That's the first part of the question. That's the first inquiry. So this instance in which you said, well, I was a subcontractor and they paid me a salary and didn't pay me overtime. You're a subcontractor if the law, and maybe if you listen to me, I say you're a subcontractor. Being a little facetious, meaning there's a number. It's a test. It's a 7-prong test, and I will tell you that you've already articulated enough that if they told you where to work, what to bring to work, provided you the materials to do the work, you're an employee, irrespective of whether or not how they pay you as a 1099 or a contractor. So that means they're on the hook for the overtime and the overtime and the minimum wage piece. So the minimum wage, when people say, well, every time I worked and I got paid minimum wage. That's great. When we talk about minimum wage claims, we're talking about work that you did for no pay at all. And that can mean, and there's some case law that says, hey, looking down at your phone, just to look at a text message, we're not going to penalize we're not going to penalize the one-offs. We're not going to penalize the employer for the one time they sent you a text on the weekend and you responded to it. But they make a habit of it. Like if they're sending you text messages all weekend long and then saying, hey, you were just answering a text, you're not allowed to be on the clock for that. That's not legal. Same thing if they say, hey, you're an editor and you're working 8 to 5 with a break for lunch, because I read a lot of your contracts. They give you like a 40-minute break for lunch or something like that, or a half an hour break for lunch, but break into the contract. But I need you to come to work ready to do everything, and everything you're not able to do between 8 and 5, you need to do at home off the clock. That's not legal. and I would be willing to bet the baby's milk money that many of you did work off the clock for which you never asked your employer for compensation because you're good people. It's still not legal. Now, the second, I'm going to pivot over to the second piece of your question, Mohammed, and I hope I didn't forget anything. I usually don't. So here's the second part. Are they allowed to pay me comp time instead of time and a half can they pay me comp time in lieu of overtime? And the short answer is no. And you articulated perfectly, Mohammed, kind of the reason why not. Comp time, if you work 48 hours one week and 32 hours the next week, and they pay you for 40 hours both weeks, what they've essentially shorted you is the 0.5 hour, if you were making $40 an hour, they basically shorted you $20 an hour for that 8 hours of overtime you worked in week one, right? So that's why it's not okay to do that. If you work overtime in a week, they owe you overtime compensation, unless you fall into some kind of exception, which is usually like C-suite level is the type of exception, and there's some administrative exception. There's a compensation. Most people think, oh, I'm paying my employees over 40 grand a year, so I don't have to worry about overtime. That's nonsense. That's one part of the test. The other part of the test is you have to have the sort of freedom. You have to have the decision-making freedom that you don't really answer to anybody. And I don't think any of you fit into that category. I mean, you think of somebody who has that kind of freedom, that would typically be me, as an example. If they hire me to be general counsel, leadership within a company, right? I would be the kind of exception. They pay me $300,000 a year to be their general counsel. That's the kind of thing that they wouldn't need to worry about me tracking my hours. That's what a lot of case law. There are some exceptions to that case law, even in Colorado, where they had a fellow who was making 180 grand a year and named as a CFO, but the employer still had the obligation to demonstrate that person spent most of their time doing that CFO work, and in that instance, the individual did not. CFO was like an additional duty. The other stuff that they were doing all day was not CFO. They hung a title on the guy to try to basically avoid having to pay him overtime, and that the law sees through that. The law looks at the time, the sort of thing you guys can remember and play over and over in your head is the economic realities test, right? So again, if they say, well, no, he was just a contractor, but we made him come into work every day and they gave him a CAT card and they had a .gov email address, then you're not a contractor. That's not going to be the conditions that satisfy the contractor status. Now, the group that shows up to the building and mows the grass, those are contractors. And most of the people who are pushing lawnmowers are somebody else's employees, but the company they hired to cut the grass, that's a contractor. The company they hired to clean the windows, contractor. Empty the garbage, janitorial service, that's a contractor. The people who work for that janitorial service are employees of the janitorial service. They don't work for the VOA because they come into VOA and 8 other buildings every day to clean the building. Even if the VOA is the only building they clean, they're still not employees because they're somebody else's employees, and they're not doing the primary and essential role of the VOA or the USPS or the Social Security Administration. Like I've got a bunch of Social Security folks who are in this case. You guys were verbatim hearing recorders. Your job is in the statute. They can't do their job. The Social Security Administration hearing offices can't do their job without you. It is required that a transcript be created for every hearing. So you're doing the primary and essential role. No one thinks if you're editing TV spots or writing scripts or editing whatever. And again, I'm going to get over my skis trying to parrot what you guys do for a living. But nobody thinks that if you're in the credits that are rolling at the end of something, that you're not part of the essential role of a TV station. So I probably gave you a wordier answer than you were looking for, but I hope that answered your question, Ron.
Thank you. Appreciate it.
Did that clear things up?
Yes.
All right, great. I'll try to keep my answers shorter so you guys don't fall asleep on me. I don't have any additional. I have some people showing up, but I don't have any additional hands raised. I think I just let in a few more people. Oh, one of my, how's it? How are you? Please correct me if I'm saying your name incorrectly.
Hi, good morning. I don't want to take more of your time, just have a question. If you did receive all of the document that I sent it by email.
I do, and I think you came in a little late. I'm putting together. I have the drafts for the amended complaint, the all of that stuff, and I'm not going to share who all the new named plaintiffs are on this call. But if you're a named plaintiff, a new addition to my named plaintiffs list, you're going to get a thing from me through the Clio portal that asking you to fact check your portion of the complaint. My fingers are crossed I get that done today. As you guys can imagine, I've got a lot of things to wrap up for us. Like I'm shrinking the size. I think you missed this part, but I'm shrinking the size of my firm significantly so that I can focus, the vast majority of my time and attention on this case. So that the answer is yes. I do have your documentation. I'm going to send out our edits to you for your review before we submit to the court.
Thank you.
All right.
Thank you so much. That was all.
All right. What else? Come on, man. This is Stump the Lawyer Day. Give me a question. Let me see. There it is. Christina, you're going to take me up on my challenge.
Yes, sir.
What is your question?
Forgive me, are you able to hear me?
I can hear you perfectly. Hopefully my voice is carrying well also.
Oh, you're doing great. Yes. Well, goodness, this is there's so many things that happened to me while I was working at that Department of Defense in addition to my children. And
Christina, hold on before you go any further. I want to make sure you know that this is being recorded, and so if there's some personal things that you want to share, you should do that with me directly over our portal together, okay? Because this is going to be recorded and published on. So if you have a question, I'm happy to answer it, but understand that this is recorded and it's going to be published on YouTube and it's going to be distributed to the rest of the group. So I would ask you, if you've got like a very specific personal question to ask me, just use the portal that we've been sharing together, or schedule a meeting with me through that portal as well, and then we can talk about it that way. Does that make sense?
okay, yes, it does. I do have something that's not so on a personal note.
Sure.
One of the things is, I was hired through a signature of a declaration of faith through to a certain religious organization, and then later on, after I went through all kinds of, them taking half my paycheck at the end of the week, I would go get it. They would just cross it out and say, "Here, we think you worked this much." Things like that. But at the end, they ended up, giving me a W-9 or whatever it is.
1099. 1099.
Yeah,
Sure.
1099. Yes, sir. And now, whenever I was working there, I also lived there, and I was promoting all the time. So one of the things that was typed up in my I guess affidavit of truth,
Yeah.
what you guys received from me, it said like I was required to work 24/7. Now, I mean, I wasn't there doing physical labor, but I did do marketing all the time. And I was always, because I believed in it at the time, I thought I was helping a lot of people. So anywhere I would go, I was connecting and pitching and, representing, you know. So I don't, that would be one thing I would be concerned with. I don't have a contract saying that I was required to work 24/7.
Yeah,
I
that
don't even
was
have a contract. Pardon?
no. I'm glad you brought that up. So that 24/7 language was actually pulled out of a VOA contract, and that ended up landing in a lot of folks. I had to go back and correct a lot of that because that ended up being copied into folks who weren't VOA folks. I've learned through this process that not even everybody who worked at VOA was necessarily caught in that. So here's what I'm going to say for your thing. Let's go back and work on yours independently, and then we'll go back and get it all correct. Does that make sense?
Okay, yeah, that would be fabulous because also just a quick throw it out there. Um, maybe we can talk to this at another time, or if anybody else has any suggestions that maybe they can pass on to you and you can give to me. But I also am in a federal case where I was representing myself pro se, and these people did 14 federal torts against me and my children. It was like a HUD, victim of a crime against women violations, ADA violations, and I've worked with many federal attorneys on it, but I've given this guy all the money that I have, and because I hired an attorney because going through this pro se, this affected my 92-year-old godfather that I'm taking care of, Korean War veteran.
Sure.
There's so many, I've written 1,700 pages to the AG and OIG. And so I don't know, perhaps if you work with these cases like that, or if you partner with anyone that can help me because I have so many, like I said, I've sent 1,700 pages to the Attorney General and I've gotten no response. I've spoken with the FBI about the case that you're working on, you
Yeah, hold on,
know.
Christian, let me pause you there. Let's you and I have a separate conversation, because again, I don't want too much of this getting published on YouTube, based on what we're talking about, okay? So let's pause
Okay,
there
yes, sir.
and pick it up there, all right?
Okay.
All right, next on my list was Ingadu.
Yes, sir. Thank you very much. Thank you for doing this and also updating us every 2 weeks. Couple of things. I will start with can you hear me?
I can hear you great. Hopefully you can hear me as well.
Yes. I will start from the YouTube. Is it a public YouTube, or you have control over who is watching it? I know you said it.
It's public right now. I have complete godlike control over it. It's my channel. So I can I can make it to private. I have a lot of strengths. Being perfect at social media is not one of those strengths, but that's why I've been very careful to make sure that I've been very careful to not use last names. I've been very careful to not, and to edit out, personal stuff. If people, I don't like people, I try to stop people like I just did, keep people from sharing personal information. This is supposed to be just a Q&A about like the case in general. And I try to limit it to that, because then it's purely educational, because I don't want to be giving away, personal information about any one individual. Does that make sense?
Yes, but if there is an option to do it, I suggest like you have control over it, and only people whom you send the links can watch it.
Well, I don't know. I only
If there
send the
is,
link. Yeah, I only send the link
mhm.
to the people that are invited to this meeting.
Yeah,
That's the only people
yes.
that get the links.
Okay, yeah. I
And
just want you to
advertise it. I don't advertise it at all. I don't promote it at all. I just
Okay.
send it to this group. So
All
somebody would have to really know what the heck they were looking for to find it on YouTube. If you do go to it, you'll see there's like 4 views. The people who viewed this thing are probably on this call right now.
Yes, missing, yeah. The other thing is, I know you mentioned it a couple of times before, but can you refresh us about the timeline on this case, roughly?
Yeah, I mean, so I'll happily do that. So, and you got to understand, I'm reading tea leaves a little bit, and I'm basing this on historical things. Like, I've been at the Court of Appeals, Federal Circuit. I think I last counted about 20 different cases that I've tried there at the Court of Appeals. And the best historical reference is the first Lambro case, which is this case once removed. I had that case fully briefed by March, and we did oral argument in December, and we had a decision in January. This time, I'm about 4 months behind that timeline. I still think, because we were able to get everything done in the summer, that I can end up in the fall or winter oral argument calendar, and then have a decision by the early part of 27. If we get that, but that's one prong of it. And I'm filing the amended complaint and things like that, doing discovery. So the case is moving. My fingers are crossed, and my strategy is simply this: I'm trying to raise the risk picture, raise the stakes for the government to a place where it turns into their best interest to resolve this thing. And what I'm trying to do from a tactical standpoint is to get them to start talking about money. Even if they start talking about a small amount of money, that is typically a thread that I can pull to get them talking about realistic amount of money, an amount of money that would make sense for you guys to say yes to and waive any additional claims. I'm not going to get you guys to do that for, for $900. There's a person, nobody's going to agree to that. That's not enough. That's not enough to make it worth your while. But I'm and the nice thing is I don't have any settlement authority. So if they offered me a quadrillion dollars for this case tomorrow, I can't say yes to it. I've got to bring that offer back to you guys, because remember, you're all individually, you're not named plaintiffs in it, but you're individually opted in by name. So I can't come back and settle this case on behalf of anybody without your consent. Does that make sense? But to answer the question you asked, I'm hopeful that we have, one, I know we'll have a much clearer picture than we currently have in about 6 to 7 months is my hope. Right? We'll know we have an oral argument date, and we'll know we'll have some more information there that will be in the throes of discovery. I'm hoping to be doing depositions within the next 6 months on this case. And if we can, if it resolves in 27, again, for some of you, I'm trying to reach back 20 years for damages. Others, I'm trying to reach back 5 or 6, just depending on how long you've been working for the agency and how long they've been withholding money. So it's unfortunately, I've had to explain this to my wife many, many times. The wheels of justice do have a habit, unfortunately, of moving at a very slow pace. But I'm hoping by the end of 2027, it would be great. I mean, in a perfect world, by the end of 2027, I'm writing some of you checks. That would be great. Or the government is, not me, but the government is resolving this thing, and you guys are agreeing again on your individual basis to accept settlements. Some of you will have, damages that are, huge, and others will have damages that are, in the tens of thousands or low, high 5-figure, low 6-figure. Those will be the kinds of cases that the government will be most interested in resolving the soonest. They also don't have my 350 or 300 sworn statements yet. That may tip the scales a bit in our favor. I'm making sure that those are right, making sure that I've got all your edits in there, and there's no deadline. Like I don't have a deadline that I'm working against to get those filed. So I'm just trying, and a lot of you have let me know that, hey, there's things that are wrong. So I've put out Word versions of some of shared the Word version with some of you, let you make corrections, bring it back in and send it out for us. All right. Did that answer your question?
Yes, sir. Thank you.
Of course. Next on my list, I have Nita.
Hi, Mr. Whitcomb. I actually tried to send you my questions on the chat, and it didn't.
No, you know what? I'm really bad. There's a Q&A of 6 questions down here. I'm so addle sometimes when it comes to getting those in here.
I think that would be quicker if you read the questions and.
I got a bunch of anonymous attendees here, so you're going to have to tell me.
Yeah, the 3 of them are from me, anonymous attendee. I didn't want to be a nuisance. That's why I didn't want to give my name.
Okay, I got you. My fault. All right. If do me a favor, folks, Christina, I'm going to mute you. If we're not engaged, go ahead and mute yourself so that the background noise doesn't come through. Oh, yes. So that's a great question. It's a little macabre, but I'll answer it. One question is if we're on a contingency fee, what happens if I get T-boned by a bus? And the answer to that is I have Forrester Haney, who's in the background. They've signed, many of you have signed engagements with them. I have a running agreement. I am likely going to talk to Gilbert. I'm in the beginning stage of that. I was very impressed with Kevin, who's one of their partners in that firm. His knowledge of FLSA, his knowledge of the Court of Federal Claims. He would be a very good backup, but it is my responsibility to, and again, if I sign 100 attorneys to this case, your cut does not shrink at all. If I sign 100 attorneys to this case, we split the fee that you guys have agreed to 100 ways. You don't, no more money comes out of your pocket. But yes, the folks at Gilbert, the folks at Forrester Haney, they're very smart, capable employment. Their focus is on employment law. They've done national level cases. They took a big chunk out of dominoes. They don't have the depth of experience in suing the federal government. that I wish they had, and they would admit that to you. They would tell you they haven't sued the federal government before. They've sued lots of commercial employers and gotten big verdicts and get big settlements, but they haven't gone after the federal government. The Gilbert folks, all they do is sue the government. So the Ryan fellow that I spoke to, I hope he won't mind me sharing this with you. He worked with the federal government. He worked for the federal government up until about the same time any of you did, right around the same Doge nonsense that happened to a lot of you. He got caught up in that. So he's got a lot of federal government experience also. So they would be my, and I haven't signed an agreement with Gilbert yet, but we just started that conversation, but there is a backup. The other one with the an attorney issue, that one, what I'd have you do is just whoever wrote me about the attorney issue, that 100,000 without my consent, send that information to me directly, and then I'm happy to help out on that. And then what is the final deadline for joining the lawsuit? That there is no final deadline, right? They're going to look back 3 years from when you joined the suit without me winning any appeals. If I win the appeals that I filed, then they're going to look back for forever and ever. I would tell you to not waste time, because we're arguing an issue called equitable tolling from when you knew or should have known about the case. If you've known about the case for 2 years, I would suggest you jump in it as quickly as you can, because when the government will argue, well, you knew about it, you didn't jump in, it's not our problem. So when you know about it, I would say that's the time to hit the stopwatch, and I would say give yourself, I wouldn't give yourself the whole 3 years, because you're going to lose time. I would say jump in, because the sooner you jump in, the farther back you're going to get for damages. That's the controlling issue there. Yeah, if you need revisions on a sworn statement, just shoot me a text through the portal, and shoot me a text through the portal. And then I was trying to do corrections on my own all the way through this thing. And what I realized is that's insane. I can't get that much done. So what I'm doing is sharing the Word document with people that want to make corrections if they haven't already signed it, or if they have. If you want me to share it with you through the portal, I'll just share it with you. You can download it, make edits, upload it back to the portal. I'll PDF it and send it back to you for signature. And I did those sworn statements on my own. Typically, that's not how it's done. Typically, you interview each individual client. You go through and you get a sworn statement. You pass it back and forth. The 350 of you, we would have all died of old age while waiting to get that done. So that is why I went the route that I did of having you guys fill out forms, pull the form information into a sworn statement, send it out for you for signature. That is not the same thing as saying we can't let you edit it, because we can upload that Word document that is essentially formatted and ready to file, and then you can make corrections in the Word version. I upload it, send it back to you for signature through the Dropbox signature page, and then you're good to go. And then we can file the corrected perfect copy, if that makes sense. I heard the lawsuit will not cover the W-2 period of our employment. That is not accurate. Most of you have heard me talk a lot about misclassification. The reason that I argued misclassification is because if you were correctly classified as an independent contractor, then the government wouldn't owe you overtime and minimum wage. But the moment you are classified, so I argued misclassification to say, hey, even though you classified them as 1099s, they should have been W-2s, and you owe them overtime and minimum wage under the Fair Labor Standards Act. If you were always properly classified as a W-2, and the government engaged in the practice that they're normally engaged in, which is say, hey, you can't work overtime, you got to work comp time, or you got to take comp time. We're not going to pay you time and a half, you got to take comp time. That still qualifies for a wage theft. That means they didn't pay you for the overtime piece. A lot of you have voiced concerns about how you weren't treated as well as the GS employees. That particular piece is not specifically actionable. I'll ask you if you're not haven't muted. Go ahead and mute.
Learn more about Freestyle Libre 3 Plus sensor along with Libre Assist at Freestyle Libre.
Trying to find a person who is unmuted right now that is coming through on anyway, if you're not muted right now and you're not actively talking to me, go ahead and mute your microphone so that you're not coming through on the All right. Russell Green, you had a question. I think I answered all the questions that were in the Q&A.
Yeah, Joe. I have two quick questions. Number one, you mentioned discovery. Could you briefly walk us through what that process is? For example, just say months down the road, you say, "Hey, we're at the discovery point in this process." What would that look like for those of us that are here in this call?
All right. So for you guys, my argument would be that almost everything the government has said, "Hey, well, look." Using Jason as an example, hey, we pay Jason everything he invoiced, right? We have the government, it was their job to track your hours. They did not do that. So right now, our sworn statement is a lot of the evidence that is going to be used to show that you guys worked your overtime, for example, or work time for which you weren't paid. The contract shows for many of you that contract provision that I've copied and pasted to many of you it reads something like VOA is a 24/7 media station. You have to be available. That never said you had to work 24/7. It said you had to be available for shifts, 24 hours a day, 7 days a week. Basically, the idea is if we want to call you at midnight to come do a shift, you got to be. It doesn't have any language in there about when you had to be, like you had to show up in 10 minutes. It just said you had to be available for shifts, 24 hours a day, 7 days a week. What I've argued is that takes away your freedom to plan stuff, to do what you can't plan week to week if you're being told that you got to be on a shift next week. But let me answer your question as it relates to discovery. The government, it's on the government. The onus is the word. The onus is on the government to show that you did not work the hours that you've professed that you worked. So they might come to you and say, Russell, give me any evidence at all that you ever worked outside of 8 hours a day. I expect that you'd have evidence to that effect, by virtue of the fact that you swiped in and out of the building on credit. And I'm going to press the government for that kind of forensic evidence. I'm going to say I want to know every time every one of these people swiped in and out of the building, signed in and out of their username and password on their computer. All of that information is in the possession of the government. Most of the effort will be on the part of the government. They have a right to try to depose people. Now, again, that would just mean you appearing on a Zoom screen, and answering questions. I'd be there to defend it, and it'd be just like you telling your story again in a sworn statement. That's pretty much the crux of the information that they could require of you would be for you, and they can't. I mean, again, if we end up with 10,000 people in this case, they're not going to try to depose 10,000 people. What they would typically try to do is depose a sample. They might try to depose 20 people of the whole group, because what they're going to hear, I expect, over and over again is the same story over and over again, right? And once they've heard that story 20 times, that starts to be very bad news for them. They don't want to keep hearing the story 10,000 times, because no one is going to suggest that 10,000 people colluded to collectively lie to the government. Does that make sense? Russell, I don't know if you were able to answer. You're muted if you were trying to answer. So if I don't hear from you, I'm going to assume that answered the question adequately. But again, they can't.
Yeah, I was having a problem getting to the icon, but no, that's good. And I think you answered my other question earlier, so that's all for me right now.
All right, thanks. All right, I think Ignatius, you were next in line. What do we got?
Joe, thanks for picking me again. I'm curious to know, as you're working to amend your complaints, are you aware of a policy at the USAGM, which is VOA at the time that we were there, where they had a clinic in that if a contractor needed to access it, we were not allowed access except you're an FTE?
Yeah, I did hear about that. Actually, I heard that through Jason, that only FTEs were allowed to access and I think it was like they had an on-premises medical facility that you could only access if you were of either. I think you had to, did you have to be, I think you had to be a GS or a PSC in order to be able to get into that.
Correct.
Yep. I'm only at the state level, the state level claims. Those are the kind of things that I'll be arguing at the FLSA level, at the Court of Federal Claims. I'm arguing purely about overtime minimum wage. The state-based claims, and I know I filed one on your behalf, that will be where that state-based, and that's in that I'm waiting on that 6 months to pass so that I can file the federal complaint. When I file my federal complaint, I can throw as many facts at them as I want to.
Gotcha. Thank you.
And that would go to the ways in which you were damaged by the misclassification. By virtue of them misclassifying you, they harmed you. Let's see. I got Lanice.
Hi, Joe. How are you?
Great.
So, my question is, when we met a couple of weeks ago, you hadn't spoken with the lawyers yet, and you mentioned that it would be unethical for you to do that. So I was just wondering, like, what changed since then?
I know. What I said would be, I don't want to be in the business of soliciting. I don't want to speak to their case until I spoke to them.
I see. Okay.
So I have had the opportunity. It's perfect. It's always perfectly fine for lawyers to talk about their claims and things like that. It would not be okay for them to share personal information they learned about you or me to share that until you've consented to that. But we talked in 30,000-foot view about the nature of their claims, which are I say the word CDA. You should hear Contract Disputes Act. That is one of the causes of action that the Court of Federal Claims is allowed to hear.
Okay.
And that is what and he unpacked for me. Ryan and Kevin and I spoke about this. I think they went to the MSPB with this originally, with Merit System Protection Board. The MSPB said, hey, these are not Title V people. So they're bringing these under Contract Dispute Act because the termination for convenience that the government threw at you guys has legal boundaries. And the position that Gilbert has taken, and I agree with, is that they went beyond those boundaries. It's like when people tell me, well, I'm an at-will employee, they can fire me for any reason. Well, the rest of that sentence is they can fire you for any legal reason. They can't fire you for an illegal reason, like terminating you because you joined an FLSA action, or in this case, because Carrie, was her name, right? The appointee?
Carrie Lake.
Had no business being appointed. Like that was just, so the way the court at the DC court ruled is that termination was basically null and void. It shouldn't have happened. And I believe some people were brought back, but like some of the folks that were brought up earlier in this conversation that had to get on airplanes and go back to their home of their country of origin, like it wasn't realistic for them to come back. But that is what changed, is that we had a conversation. I feel very good about both. I think it's kind of a 1-2 punch type of thing. Now, if the Court of Appeal, we've already talked about this, the Court of Appeals agrees with me and says, hey, this retaliation claim is legitimately in the Court of Federal Claims, then it could be that the damages for both cases are subsumed in that FLSA action, right? And that retaliation claim.
Mm-hmm.
But that's still a high five for everybody, because that's still getting your contract damages plus ×2 going forward forever, theoretically, right? So that we're all very comfortable and happy with that outcome. So we're kind of in, I'll be a little bit tongue in cheek here. We're kind of at the dating stage. I like these guys a lot. I think they're smart, and I appreciate the angle that they've taken, and it's creative the way they've brought this. And they seem to be impressed with the thing that I've invented here with this FLSA action, because I think I've told most of you till you're sick of hearing it, that the reason that this is going, a lot of the reason that this is going the way it is because I'm the first person to ever try it. So that's one of the reasons. That's one of the reasons it's taking up so much time. I'm kind of creating case law every time I do something.
Oh, okay.
And they're doing the same. This CDA thing with the PSCs. I'm using a lot of acronyms, but no one's ever tried that on a scale at this level. With the background being the government engaged in an illegal appointment of no one's ever tried that before, to illegally appoint somebody to the top of the food chain.
Okay. My other question is, if you were one of the PSCs that actually went back to VOA, could we still join the other law firm's case as well?
Well, you'll still have, my expectation is you'll still have contract damages, because there was a period of time which you didn't get paid. Now the risk will be if you've signed any releases sometimes I'll be like, hey, we'll dangle this job in front of you if you're willing to come back, as long as you sign all these releases. And hopefully you consulted with counsel before you did that. If anybody signed releases, because a lot of times they'll try to get you to sign a release that says they can come to your house and huff and puff and blow it down, and you won't sue them for it. So that you got to be very careful before you sign anything to ask somebody with a legal background to read it.
Oh, I see. Okay.
All right.
All right. Thanks.
Of course. Nita's hand is back up. Nita, what's going on?
Yep. It's just a follow-up to my questions.
Go ahead.
I sent back my request for revision to the sworn statement to your email, but you
Okay.
just mentioned today that I should send it to the portal and that you were going to send me back a Word document for edits.
Yeah, I'll if you go to the portal, and by the way, the portal link should be in your inbox. I get a message. So the reason you guys hear me talking about the portal so much is, as you guys can imagine, I get an absolute ton of emails every day. I get about 250 emails a day. If you put something, and there's a risk, I do a diligent job of making sure I don't miss emails, but I'm human and I miss them. If you put it in the portal, it puts a red dot next to your name in my system, in my case management software, that won't go away until I read it. So, and if you put a document there, it goes into your case and it won't go anywhere, right? So if you have and you can use the text message in there too. So if you use the text message or the portal, right? The text is like you do from your phone, obviously, but they both show up inside your case, and those communications get saved within your case, and there's no risk of me having to go through Outlook and find out where you sent me that, or that nightmare, right? So if you send it through the portal, or you send it through the text, you're like, hey Joe, this paragraph is wrong. What I'm going to do is just upload the Word document to your portal, have you download it in Word, make your edits. Some people have made comments. I'm happy for you guys to redline it or make changes. And when you upload it, I'll feel confident that it's good, and I'll send it back to you for a signature through the same portal. I'll PDF it and send it to your portal through Dropbox Sign for you to sign it. And it'll go. And then once you sign it, again, it lands right back in your portal. So there's a 0% chance of me losing it.
Okay. Another quick question. What if I cannot find my older contracts? Like, can you get those?
I don't think you should worry about that. I mean, find them if you can. It's helpful because that way I can use them to call the government a liar if they lie to me. But there's 350 of you, so there's a little over 300 of you right now. And the contracts were pretty much cookie cutter. So I don't need to have your particular. I'll get it, but what I can't get from you, I'll get from the government in discovery.
Okay.
That makes sense. What else? Yeah, I think you cut yourself.
Yeah. So if are you going to look into other benefits that we didn't get as W-2 that we should have gotten in the first place, or is it just about overtime?
So there's two claims going on. One is the FTCA claim, which is the state-based claim. So if you live in a state, and many states say this, that say misclassifying someone is illegal flatly, and then by doing so, they invite the damages that they would have that are created by the misclassification, right? So we will argue that had they classified you properly, you would have gotten these benefits. You would have gotten all the things that you guys have listed, and there's a long list of them, right? And then it'll be up to the court to say, yeah, that is an accurate, and we'll hire experts, right, to say this is what it cost Nita to be misclassified. If you were classified as a PSC, then your benefits will be governed by contract again, unless because the FLSA, the Fair Labor Standards Act, does not speak to what kind of benefits you're entitled to. It does speak to state law. State laws in each state speak to what benefits you're entitled to, including things like collective bargaining and things like that many of you didn't get to take advantage of. But so they're going to be handled. The answer to your question is yes, they'll be handled, and they'll be handled in the two separate cases that we have filed. And if a third one pops up that I learn about some statute that creates a new cause of action, I'll certainly go after it.
Thank you.
Inge, you had another question.
Yes, sorry to hold you over an hour. Can I update my sworn statement that I already signed?
Yeah, do the same thing I just instructed. Yep, just shoot me an email. Again, this is your sworn statement. And it's not like that we're not in, I always joke with we're not in middle school. This isn't the world of no take backs, right? So if you have a correction, until the court actually rules, we can update statements and update evidence and things like that. And the court hasn't ruled because, it's been slow to do very much. But yes, it's the short answer. You can update.
So,
reason update your, I'll send you the Word version of your sworn statement. You can read through that. And again, I haven't actually, the thing that you guys don't know is that I have not actually started I'm about to submit a small group of these sworn statements related to the amended complaint. Before I do that, I go through the sworn statements to make sure that stuff that landed in there, that everything that landed in there should have. And in the instances where they didn't, I've sent them out to those folks and said, hey, I made some corrections. Please look at these corrections and re-sign. The most important thing that I needed to get done with you guys, and I wasn't, messing around with your time or anything. I have been trying to get sworn statements from a lot of you folks. I mean, from the group, not from any individual, but from the group for about 2 years. And I had paralegals calling folks and trying to get, and I had my wife sending out portal and certain and people just didn't know what to put in there. So I created the form as sort of a catch-all. So I get something on paper and get the sworn statements down. We're going to go, if we need updates, that's an easy thing to update and fix, right? But if we, and I'm going to, before any of these things get submitted, I haven't submitted a single sworn statement to the court yet. Before I do, I will personally read every one of those and make sure that based on what I know about the particular agency, because the Social Security Administration offended in ways that are different than the VOA and different from the USPS and different from DOJ and state and so forth. So I'm going to make sure that they're all right. And then, if I see something that's incorrect, I'll just either fix it and send it to you for signature, or if, like in your case where you say, hey, I found something that I don't think is right, I'll just send you the Word document, and you can fix it. You can that thing. I think that's going to be the easiest way, because if you try to do it like an Adobe, it's going to be a mess. But if I give you a Word document and you fix it and I upload it, it's clean and it's ready for signature.
okay. Do I need to shoot you an email, or you just?
You can just. My preferred way is to either use the portal, either the text message. I think everybody here has gotten a text from me through the portal. It's like an 833 number, and if you use that, that's a great way to alert me. Or just use the portal. Again, because I worry about stuff going to the email abyss. But if it's in the portal, then I can't lose it.
Okay, thank you.
All right. Let's see here. I think. All right. Look, I have Christina. I'm gonna ask you. We're gonna get on a call anyway, so I'm gonna ask you to hold your question until you and I have an opportunity to
Oh,
speak.
it was just before I lose the thought. It was just about you saying you didn't get a lot of feed or signed petitions or statements. I was kind of hesitant to sign it because I was like, oh my gosh, I'm locked into this statement. So I was just going to give a little suggestion. Maybe you throw a little one-liner out there. Hey guys, for those that haven't signed, please know that we can update this. Don't be, and that might take a little pressure off of them, because it really did kind of give me a little pressure, like, oh crap, I'm really locked into all of these words.
That's a fantastic point. I will, and I'll do it when I send out the update on this. I'm going to bring that. So everyone knows. I think almost everybody on this call has heard me say this before. I'm going to get this recording back from Zoom here in a minute. When I either tonight or tomorrow at the latest, I'll send out, hey, the thank you for meeting with me email that I send out. I'm going to raise that point, Christina, that many of folks have been hesitant to sign the sworn statement because you're worried about locking yourselves into a statement that you're not 100%. This is your sworn statement. It's important to me that it reflect your truth. So now there's some stuff some boxes, so to speak, that I need to check legally to make sure that if you're going to qualify for the case, like that kind of thing. But the specific facts that are relevant to you, it's your document, and so I'll make sure that is clear. And I appreciate that suggestion, Christina. All right, guys, it's 11:13, and we're going to keep doing these every other week. And if there are no other raging, fiery questions, I'm going to give you guys the rest of your Sunday back. I'll send out an email again with this video, and I'll make sure some things clear. One of the things I'll probably need to make clear is, like, just because the form link is in the email doesn't mean you have to click it unless you haven't done it before. And also, if you've got issues with your sworn statement, use that portal or email and say, "Hey, Joe, Carolee, there's some issues. Can you?" And again, if you just say, let me have my Word document so I can go after it. Like, I'm happy for you to add information that I've missed. It doesn't need to be limited to the questions that I asked. If there's something that you guys think was real, like one of you brought up today that, we weren't allowed to use the on-site medical care facilities. Even if it's not incredibly relevant for this case, I don't care if it's in there. It's perfectly useful for it to be there. Jody, is it all right, guys? I'm gonna go ahead and let you guys go. It's 11:15, and first of all, you guys will all die of boredom watching this thing if I let it go much longer. All right,
Thank you very
we'll see you
much.
guys. We'll see you guys in a couple of weeks.
Thanks, Joe.
All right. Thank you.
Thank you. Bye, guys.